Hello and welcome to another episode of A Question of Law. It's a City TV's legal education program, and here we seek to educate you on all the different legal implications of various things that happen in our daily lives, daily interactions, and all that goes on. Well, I have my guests, they're seated. After this break, I'll come back and introduce them to you. Don't go anywhere. Welcome back. My name is David Kwekusechi, and again, it's a question of law. My guests are seated here. I have with me Clement Kojo-Akapam, who is a senior law lecturer at the Faculty of Law, GIMPA, and also a private legal practitioner, and also Salom Adonu, who is also a private legal practitioner. Good morning. Good day, gentlemen.
Hi. Good day.
How are you doing?
Happy New Year to you.
Yes, Happy New Year. And, well, it's in the new year. And what's going on in the legal front?
I think we've transitioned very well from December. We saw the effect of law at play in December.
Yes.
Against the first night.
I know, right?
Well, against the last day of the year.
Yeah, last day of the year, right? Yeah.
So I think that was interesting. Well, there are positives and negatives. But clearly we've seen that we are enforcing certain provisions to bring sanity. The purpose of law is to bring order, so that one's right is not held in the face of the other.
Okay.
So that we can all live in peace and harmony. And I think that should be the use of law to bring order. So I think that some order, even though there are other areas that we might have to look at in regulating what the police sought to regulate, which is the prophecies that might become injurious to persons.
One may even go as far as asking that what's the constitution of Umofia?
I say that increasingly we are seeing enforcement of law. I think that we should take it to other areas. This year I'm hoping that we will be very strong in enforcement of our road regulations, particularly when it comes to speeding limits, when it comes to validity of driver's license. These little things are the things that
they make all the difference.
They make all the difference. You understand? So someone knocks you, he has a car, the car is insured, the car is roadworthy, so your medical is not an issue, the person has a valid license, so everything just flows. So this year I'm hoping that we will increase that sort of for our own safety. So I'm looking forward to an interesting 2022. Obviously Parliament will give us a lot of fodder to once they return for us to chew on. They left on an interesting note. I think that very soon we might have to look for time and look at football and the law as well.
I know.
Because
whether certain red card offenses are actually red card offenses or not.
Yes, on the field. How the relationship between the on-field referee and the off-field referee, all those decisions, what are the basis for that? Engagement of coaches, what agreements do you have with them? Engagement of players, what are the terms and conditions, so that if you've been invited to camp and you don't deliver up to a certain level, what are the rights? And it will be interesting. Maybe we should start a little research into that.
I like that.
That would be quite interesting. And what kinds of people can we invite into camp when you know that reasonably this person will not be fit before the start of the tournament or throughout the life of the tournament? Do you risk and invite those people? It's interesting, but let's see.
And if you invite that person, the person does not perform, where lies liability?
Yeah.
Must we go back to the drawing board? I hear the drawing board is no longer there because the board is started.
It's being reconstructed.
The board is started. I mean, interesting. So, also on the political front, quite a few legal issues coming up. We saw Atifosin and Co. in court this week.
Yes.
They are on bail over the charge of causing financial loss to the state on the matter of the ambulances, the 30 ambulances that were imported into the country, and the claim is that they were not fit for purpose, and so the letters of credit, etc. I mean, and all the processes that dogged that led to a certain financial loss, a willful financial loss to the state, and the courts, started sitting on that yesterday, and so as it is, they are on bail as we speak. So that's interesting. That's one to look out for, to be charged politically, because the parties have started talking. I mean, at least persons around them have started talking on matters in the case, though they all claim they are not dealing with the merit of the case. The other one has to do with this petition by the Fix the Country movement in respect of the impeachment of the EC boss and her deputies. That's an interesting one. And the matter is that, their issue is in respect of the South, area, the Santrophi, Akpafu, Lolobi, and Likpe area. If you recall, a day to the election also, a press release was issued from the Electoral Commission stating that the people in those areas will not be able to take part in the election. And so Fix the Country movement is taking on the EC boss for that her action disenfranchised a lot of people. And as we speak, people in those areas are not represented in Parliament, and that is not good. So the procedure has been triggered. The law in Article 146 says that when a petition is submitted to the president shall transmit that petition to the CJ, to the Chief Justice, who will consider or look at it and see if there's a prima facie case made out, in the petition. And if he comes to a conclusion that a prima facie case is being made, then he'll proceed to the next step of setting up a committee. And Article 146 describes or talks about the composition of the committee, what it should be. And it says that it should consist of 3 Superior Court justices who will be appointed by the Judicial Council, and then 2 other people who should not be lawyers, should not be judges, should not be members of the Council of State, etc., who should be appointed by the CJ. Those 5 will have to sit and deliberate on the merit of the petition and come to a conclusion. And when that conclusion is made, it is transmitted or reported or given back to the CJ, and the CJ transmits it to the president, and the president will have to deal with the petition, implement the recommendations of the petition. So I think that will be an interesting one. I don't know how it will end. I don't know how it will end, but it will certainly be a major talking point in this first quarter at least.
No, it's so interesting that the process has started according to the Constitution, petition sent, because it has to be a petition now. I mean, you will wonder, why is the removal of the EC going through the presidency? So if you look at the appointments of the Electoral Commission, if you look at Article 44 of our Constitution, it says the chairman of the Electoral Commission shall have the same terms and conditions of service as a justice of the Court of Appeal. So the important point for us here is the same terms and conditions. So it means your salary, your vacation, your removal processes. So that's what brings in Article 146 on the removal processes. Because if you go to Article 146, you will not see Electoral Commission mentioned there. You see removal of justices of the superior courts. But because a justice of the Court of Appeal is a justice of the superior court, he is removed according to the procedure in 146.
Okay.
So when 146 is triggered, as Selom laid out clearly, in relation to the Electoral Commission, it is because the Constitution pegs the conditions, the terms and conditions of the appointment of the Electoral Commission to that of a justice of the Court of Appeal. So then the removal processes will be similar to the removal process for that of a justice of the Superior Court. So the key requirement is the determination of the prima facie case. So once the petition is submitted, as Selom laid out clearly, it is for the Chief Justice to determine that at first sight, prima facie, is there a case to be answered. And then once that determination is made, then we go into the process of...
When you say prima facie, that basically means what? It means that...
At first sight.
At first sight.
Looking at the facts.
Okay.
Without
Is there
a case here to be
Okay.
answered?
Okay.
So once that...
But Clement, wouldn't that lend itself to a lot of subjectivity?
No, so I hold a certain view when it comes to members or chairpersons of independent constitutional bodies who are removed the same way as justices of the Superior Courts. I think that we did this benchmarking in the Constitution to bring some uniformity, but I think that the work of an electoral commissioner is not the same as the work of a justice of the Court of Appeal. And if you look at the removal processes and even the composition of the committee, you have 3 justices of the Superior Court. And I'm saying, yes, the judges, they hear all other cases, so they should have the competences. You have 2. But I think that we should have clear removal procedures for electoral commissioners and commissioner of Shraj, and not, because it is now left to an individual, the Chief Justice, to make that determination.
Okay.
And I think
It's quite an onerous determination.
it's very heavy.
He has the power to determine whether the process will continue or not. Once he says, I don't find or see any prima facie case in this, that's the end of the process. Yes. If he says, no, I see a prima facie case in this, it means the process will have to continue.
And that determination is very important, because if you look at our Constitution as we have it now, the provisions in 146, when it comes to the removal of the Chief Justice, the text as we have it in the Constitution, you won't see the requirement of a prima facie.
Yes.
So this was taken to court.
Okay.
And in the case of a J-Chum, the Supreme Court, speaking through Dateban, will clearly say that you need to have made a determination of a prima facie case. Because if you don't do that, then what it means is that once the process is triggered, a committee is set up and the process must go on.
Yeah.
But at first, let's establish. Now,
actually
who should establish, the Constitution says, is the Chief Justice. Okay. So that's a very interesting issue that we'll have to keep our eyes on whilst
it's interesting. 146 also talks about what can trigger the removal process. So there is the issue about stated misbehavior.
Okay.
There's the issue about incompetence and the inability to perform the functions of the office, maybe due to infirmity, etc., etc. In the case of Charlotte Osei, I recall that the main plank for the decision of the committee was on incompetence. And you see, that was just, after the election where there was a lot of talk about incompetence. And so that her case of incompetence was in respect of how she dealt with the procurement matters.
Yeah.
So the committee was of the view that she incompetently dealt with the procurement matters, and based on that and a few others, she was not fit to be in office. We don't know how this will travel, but it's certainly an interesting spot to really look at.
All right. Well, we're going to take a short break and we'll be right back. Don't go anywhere. This is A Question of Law. Welcome back. It is a question of law. And the WhatsApp line is 0550585832. We definitely want to hear from you right here on the show on any questions that you may have for our legal panel to answer for you. Now, we've been talking about matters arising so far in 2022. One of the big issues that has come on the front burner is the issue of the SIM card re-registration. And of course, towards the tail end of last year, we saw people, queuing up and all that. But the question now is, who is it that's keeping our data? And what's the law as far as this is concerned? What's the law on who holds our data and who has the right to share that data with whom? Well, my gentlemen are here, and this matter, yeah.
Well, who is holding the data?
Yeah.
And who must hold the data?
Okay.
Or who is mandated to hold the data? I think that that determination has been made already. I mean, when it comes to this area of data, because of the rules on privacy, and our constitution is very strong on privacy, protecting our correspondence from being unduly interfered with. So the constitution gives us the right to privacy, and one of that will relate to our correspondence, and also when it comes to our property. So when it comes to data, we have a very elaborate legal framework. Actually, one of the areas that we'll say that is heavily regulated in Ghana will be issues of data, their usage, and the rights surrounding data protection and all that. So we have established clearly a Data Protection Act, and that Data Protection Act will set up the Data Protection Commission and then give it functions. And it's the key function is to ensure that persons who collect data are using the data according to the dictates of the law.
Okay.
So first, to even be permitted to collect data, you should have been in the registry of the Data Protection Commission.
Okay.
And then there will be certain guidelines that you must fulfill when you are processing the data, when you are using the data, when you are disclosing the information that you have collected. So yes, we have a regime for data protection. Now to the specific issue of SIM registration. Now what are we doing? We are registering our SIM cards. Now in registering our SIM cards, we are required by law also to provide identification.
Yeah.
Now two things here. The exercise of the registration of the SIM card is a function that falls squarely under the Ministry of Communication, acting through the NCA squarely.
Okay.
Now, the issue of documentation to provide for your SIM card to be registered, that is within the domain of the National Identification Authority. Now, let me point this out to you. See.
Okay.
In 2006, we will pass the Subscriber Identity Model Registration Regulation, LI 2006 in 2011.
Okay.
So LI 2006 in 2011 will say in Regulation 2 that a subscriber shall, for the purpose of the registration of the subscriber identity module, which is the SIM. So today, you know that SIM means subscriber identity module. So that's what SIM means. So of that subscriber will furnish the network operator or service provider with the following information.
Okay.
And then it will list the things that you must provide for your SIM to be registered. But then in paragraph 2C, it says an identification document, meaning as part of you giving them your date of birth, if it's a company, your incorporation and all that, you must provide an identification document.
Okay.
In that same regulation, LI 2006, it will define identification document to include a number of things.
Okay.
Valid driver's license, passports, will give us a long list. However, In 2012, we will also pass the National Identity Register Regulation. Okay. And this regulation is passed pursuant to the National Identity Register Act.
I see. Okay.
So it is this National Identity Register Regulation that will regulate how we collect information to store in our National Identity Register. And this is in the domain of the National Identification Authority. If you look at Regulation 7 of LI 2111, it says, a national identity card issued to an individual shall be used for the following transactions where identification is required.
Okay.
And one of the transactions where identification is required is registration of SIM cards. So if I'm going to register my SIM card today, the valid document is the national ID. So that's why everybody is rushing for the national ID. Now, what is the issue that has come to the fore? When you go to the telcos are also now taking information from you, which includes your biometric data.
Okay.
So now this biometric data, is it going into our National Identity Register? Is it sitting in a private register? Is it being collected under the framework of the data protection laws? That is where the question is.
Okay.
And I think that a right to information process was triggered and the NIA has started answering questions. Because if you are collecting data, which data you are going to use to verify whether someone is in the National Identity Register, the way you collect that data, how you store it, is very important. Because then at the end of the day, it should be able to fit into the National Register so that you can cross-check if the information you are giving is right or wrong.
Okay. So not to cut you, but let me just quickly read a story from citynewsroom.com.
Right.
It says here, NCA, NIA must clarify concerns about SIM registration exercise. It's an article written by Selam Brante. Right. And it says, and I'll read all of it. It says here, Selam Brante, a leading member of the protest group Concerned Mobile Network Subscribers, has called on the NCA and the National Education Authority to come out and clarify teething concerns about the ongoing SIM re-registration exercise. According to him, a letter from the NIA responding to queries by a concerned citizen strengthens their case for the process to be halted. The letter has gone viral on social media, among other things, has the NIA indicating that it is unable to confirm that the biometric data to be collected by the NCA for the purpose of SIM registration will meet the standards necessary to be verified against the National Education System, which is a database. Okay, and then the quote here says, NIA cannot endorse or guarantee the quality of biometrics to be captured by NCA during the said exercise with the devices that NIA has not duly certified.
Right.
Okay, so these are...
So you see,
yes,
NIA is the entity created in law to collect
the data. Yeah.
When it comes to the creation of our National Identity Register. And actually, it is the head of the NIA who is made the custodian of the data. So if anyone else is collecting data that will be used by the NIA or with information in the NIA identity register, that process or the device being used, at least the NIA must have a role to play in it.
Yes.
To be able to say that, oh, the way you're collecting this data, yes, when you plug into our system, you are able to cross-check.
Yeah.
The NIA must be able to say that the way you are collecting the data, we don't think that you will get accurate information when you plug into our system.
Yeah.
So I think that there's a certain gap between what the NIA has in its system, what is currently being deployed by the telcos to collect biometric information, and whether or not it will be useful at the end of the day, so that we are not subjected to queuing again to have to
do another
to do another exercise. But for what is worth, I think that we've gotten to a point in our development where NIA now can confidently say that with the persons that they have registered in their system, there is a functioning national identity register that can give information on Ghanaians. So if we want to verify information, I think that where to go will be the NIA. And I mean, this area is technical with all the technology that comes with it, but just it clearly shows that there's a certain gap in communication between the two institutions, because clearly one is set up to do SIM registration, another is set up to collect information. So I'm doing my SIM registration, and this is how I want to do it. And these are the processes I'm using. Okay, I'm also collecting information for the national register. This is how I'm doing it. So I think that is more of an issue of bringing the two processes together and to see that at the end of the day, whether any subsidiary collection of data can fit into the national identity register.
So my difficulty here is, it seems simple as a layperson, okay, for you to say telcos or NCA, the NIA database is set up, it's ready, it's functional, right? Plug into the back end. If you want to verify anyone as being who they say they are, put their data against what is in the database, and then we'll know whether it's the person or not. What's so complex about this that we, a separate database seems to be, NCA is trying to create a separate database, and is it even legal?
So surely that is a difficulty. The creation of the database, of course, the NCA, I think, has said NITA is keeping that information. I don't know how true that is.
NITA?
The National Information Technology Agency is keeping the information. I don't know how true that is.
Okay.
But as far as we know, the custodian of personal data of Ghanaians really is the National Identification Authority.
Okay.
And they've deployed quite an extensive system across the country to collect data. The last count, we heard about 15.5 million people have been registered, also a number of cards issued, etc. And they are still in the process of doing same. So clearly there is some process ongoing. What is not clear is what level of discussion or engagement went on between the NCA on one side and then the NIA, which is the custodian of the information. Now, in that letter from the NIA triggered by the right to information operation, I should say, the NIA appears to be saying that the data, as far as we are concerned, is useless to us because, one, we are not sure about the process of the collection of the data. How you collect the data is important because if you are going to verify that data against what is in my system, there should be some compatibility. How are you collecting your data? And I should have a say in how you collect your data because mine has been there already, or mine was first in time. And so you are going to be verifying yours against mine. And perhaps mine is even bigger because mine covers a larger group of people. So it appears no talking, the two systems didn't appear to have spoken to each other. That is how come the letter from the NIA will sound the way it sounds. And that is a real problem. The application being used, etc. The NIA is telling us they cannot vouch for the integrity of the application and the tools or equipment being used. And that is a major issue.
So on point, but that does not also mean that they have said that the system they are using is not good.
No, they say they can't vouch.
So it's neutral.
It's neutral. So they don't know.
So that's what
but the bigger point I'm making is that they should have, at this stage, they should know. So to say that I do not know whether it's right or wrong, I mean, somebody could argue that's a diplomatic way of saying, the West. But of course, that's what they've said, that they cannot vouch. So they cannot vouch is they cannot vouch. The other point about verifying the data. So in the first SIM registration, I don't think there was biometrics. So the big deal these days, there wasn't. The big deal these days is the biometrics. Yes. So if there's no biometrics in the first one, and the biometric is so important because somebody could use just any name to register a card. And of course, a lot of the cards in town have been pre-registered. Yes. They have been pre-registered. You can just walk to a SIM card sale point and buy a card without registering. You can use it because it's registered already. Though it's very dangerous.
And
people do it.
Else's name
and that's very dangerous, but people still do it. So what it means is that there's a difficulty or a problem. The integrity of that first system appears to have been compromised. And so they think that using the biometrics will make it easy for that verification to be done. I don't know how they intend the two systems to talk at some point, especially as we do not know whether the two systems are compatible. So if there's no biometric here, what will they be seeking to verify? Is it the name? The name that, in some cases is not correct because the cards have been pre-registered. So I think that is the gray area or the point that we must seek further clarity on. The first one was not biometric, and the biometric is a big deal. My name can be Kojo Mensah, but which may be wrong, but the biometrics cannot be wrong. No. And so if the same biometrics is in the NIA system, it's easy to verify that, okay, these biometrics are similar, but the names are not. You flag it up, and whatever there is will be sorted, So that is my thinking around it. I think that area must be explained to us properly so we can make progress on that.
No, but so I don't think that there's even a problem with sharing data because the NIA is mandated under conditions to also give data.
The NIA is even saying that the modalities haven't been discussed.
So question, is there any law that covers a third party holding your data?
So you see, that's what I'm saying. If it's data from the NIA, so for instance, when we went to register for the Ghana card, they took our information. So if the NIA is giving this information out, let's say to MTN, there is an agreement that, according to the law, they must enter into. And that agreement has a clause on third-party usage. So it doesn't. The data is collected not to be stored. The data is collected to be used under certain conditions. So once the NIA gives you access to data in its custody, you enter into an agreement with them, and the law will exhibit a form of the agreement. And then the terms of the agreement, one of the key terms in there you see is third-party usage. What you can do, what you cannot do. So all the terms are in there. So if you want data from the NIA for a particular purpose, and it's within its mandate to release that information to you, you enter into that agreement. And third-party usage is clear. I think that, yes, I agree with SIM registration. We must do it for the purposes of ensuring that you know the person behind the call. Because and all the things that are happening with e-theft, all the things that are happening with the fraud of fraudulent transactions going on because of not knowing who is behind. So yes, it's important. But we should also know, I am better off giving my information to NIA because NIA is a national agency. Am I protected the same way if I go and give my biometrics to MTN, to Vodafone, or to any of the telcos? What level of, so if that information falls into the hands of unscrupulous third parties, what can they use it for?
Mind you, many of these companies are not indigenous.
Yes, and then it's a greater risk actually if that information falls. So now the person doesn't only have your name, the person has your name, your house, your digital address, and now has your fingerprints,
your date of birth and fingerprints,
and even
your iris,
your iris or pupil or whatever they take when we look. So yes, it's a big deal. And once that information is being taken anywhere, there must be clear guidelines on usage, storage, and even third-party usage.
That is why it's troubling that the letter from the NIA, you know, it's practically saying that we know nothing about what's happening.
Yeah.
That should be very troubling. The NIA should be seen actively working with the NCA to make this process seamless. So this letter is very pregnant. We only hope that we'll have the right responses from the NCA and the ministry in general, so we have our way clear before us. Because the data that the telcos are getting, you know, I don't even understand what the rules are. How do they transmit the data? Are they storing it somewhere before transmitting it?
Yeah.
What are the protocols? What are the rules? We do not know. And it could so happen that some of them will be storing the data. Is there a way to ensure that they do not get to store it? Mm-hmm. And how does application work? Does application talk directly to the database, the NCA database?
But isn't that exactly? I was going to ask about that. Isn't this a case of what the NCA's setup looks like? So the telcos transmit back to the NCA, and whoever the NCA says that it's mandated, that if it's NITA, then it's NITA. That means NITA is collecting all the data.
No, but we do not know.
Okay.
I do not know.
Yeah.
So that's why I'm saying that it's important that we open the channels properly, so that this clarity is brought to the discussion. You know, the information could be there, but if you do not share it and people do not know, the people could have legitimate concerns, like what we are expressing. The two bodies, NCA and NIA, I think must sit around the table and iron out the difference. If it's not so necessary that this SIM registration be done, and NIA thinks there could be another way of doing it to achieve the same result, why not? It even saves us on the social front. The massing up of people at registration points, the insufficiency of these registration points, etc. People having to ask permission from work the whole day to go do that. You know, whether it's even useful or necessary to do the two-way registration. I mean, it's a lot of stress on people, to put it mildly. Yeah. If the two bodies can sit around the table and devise a means of making it more convenient and more dignifying, I think it will be better.
I think that when we talk about this SIM registration, it was just a couple of weeks ago that I realized that even your data SIM cards will have to be registered. So it's not only the SIM cards in your phone, so your data SIM cards. So they are even...
you have access to things you do on the internet.
Yes, so this the short code that you're supposed to dial. There are some data companies that do not. So yes, we want to do it. Yes, we want to solve a problem. But as Selim said, we do it within the strictures of the law. We give information so that people are comfortable, so that it doesn't look like you are being pushed into a certain black hole. You get up and you're queuing, but you do it, and then we will get the benefits from it. Because now you have your SNIT biometric, your NIA biometric, your TIN also
your
is linked.
NHI is biometric.
It's so
a lot of them.
At the point in time, and I am hoping that with all the discussions we're having, we will not get into an election year and we'll be having discussion on the new card.
Yeah.
I'm hoping so.
Yeah.
Yeah.
Okay. So basically, I think that this is a good way to conclude this matter. So all our cards, the idea of it is that we are synchronizing all cards, so that with the NIA card, you can simply use that card. It gives you access to all the different services and functions that you may need to perform as a citizen of the country. Right. Yeah. Okay. All right. Well, we're going to take a short break again. This is a question of law. Don't go anywhere. We will be right back. Welcome back. It's time now for the docket. This is the segment of the show where we take your issues, your challenges that you've sent to us, and then we try and seek some legal education in these matters. Of course, the WhatsApp line is 0550-585832. If you have any issues, please don't hesitate to send them, and we will seek to address them here. So please help me. This one is for the docket today. Please help me. A colleague of mine is accusing me of sexual harassment. The basis for this accusation is beyond me. So here's what happened. The male and female washrooms we use in our office are close to each other. While visiting there about a week ago, I heard strange noises coming from the female washroom, so I decided to investigate. When I opened the door, I saw one of my colleagues with a horrid look on her face that resembled someone who was choking. She couldn't talk, so I made a hand gesture to ask what was wrong with her. She pointed to her back, so I immediately opened her zip and she started breathing. While I was soothing her back and asking if she was all right, another lady colleague entered the washroom and immediately saw the scene before her, and she quickly left. I was attending to the other lady, so I didn't really pay attention. I thought she was going to get help. Later in the day, after this incident, I was invited to the HR's office and slapped with a complaint of sexual harassment. Apparently, the lady I helped claimed I touched her without her consent. I explained the situation to the HR and told her I only touched her when she pointed to her back. All these explanations have fallen on deaf ears, and I am about to be handed a 3-month suspension letter if the disciplinary hearing does not go in my favor. I was having a conversation with another colleague about this issue, and he informed me that this whole accusation was fueled by the lady who chanced upon us during the episode. She and I were involved once and had a very public altercation, which had me suspended. For some reason, she's been able to convince the lady that I saved that I was only taking advantage of the situation. The lady is threatening to sue the company and me if nothing is done about this. What should I do? Should I call her bluff and allow this to go to court? What evidence do I have to prove my innocence? How do I entangle myself from this mess? How can the law help me?
So,
it seems pretty entangled.
Yes.
Is it as complicated as it seems?
I think that the main theme running through it, workplace relations, workplace interaction, because you hear HR, you hear sexual harassment, you hear office.
An ex partner.
Yes, so it's workplace largely. And to solve most of these problems, you see that a number of organizations will have HR admin manuals, certain do's and don'ts. Well, if I personally hear a sound in a female bathroom, I'll call a female to go in.
Okay.
Because the danger is that you might go in and she hugs you and starts shouting rape.
Okay.
You are in deeper waters than if you had walked away and called a female to assist. So, but the reality of the situations that we are very emotional beings and want to. But sexual harassment in a workplace, so if you have your HR manual that determines what amounts to sexual harassment, then if you breach that code, because I hear also a disciplinary committee is going to be look at it. So you'll be invited to this disciplinary committee. What evidence do you have? It's your oral evidence. And that will be against the person who saw what you were doing. You will be given the opportunity. And at that committee also, it will be important to discredit the witness by indicating that, all this is happening because we were involved, another workplace issue, because there are certain workplaces that you are not allowed to have certain relations.
Okay.
So was that permitted there? Okay. You need to bring that up to try and discredit this witness, so to say. But at the end of the day, it will be a question of the complainant's allegation that you sexually harassed her, and then your defense to say that this is what you did. And from the narration, it was a hand gesture that said that, did she point to her back, or how did you know that it was her back, and how did you know that you had to unzip? I mean, so we'll go into all these, but it's a committee, and this committee will listen. They'll look at your demeanor, they'll look at, but if the person wants to press charges, yes, you cannot stop the person from pressing charges when the person feels that he's been sexually violated. And that sexual violation within our criminal context will fall within our criminal law, and the person will take action. But should he call his bluff and let the person go to court? I think that the first step is that there's a determination by the disciplinary committee. And if it's in your favor, you continue to work. If the disciplinary committee comes to a conclusion that you sexually harassed her and they suspend you, and you think that the disciplinary committee reached their conclusion in error, you also have a procedure in law to get that decision quashed, that administrative decision quashed. But then if the complainant also thinks that the disciplinary committee reached a decision in your favor, she can also find a way of pressing charges.
Right.
Yeah.
So yes, I think Clement is pretty much dealt with the whole thing. I mean, quite interesting situation we have on our hand. So there's an element of touch there which makes the claim or the allegation of sexual harassment even more serious, because you can be harassing somebody sexually sometimes without even touching the person. So once there's an element of touch, it makes it a bit more serious. But there could be, or there is an element of consent, even though that will have to be looked at properly, because you said the person made a gesture to the back. Maybe you are very good at reading sign language, so you read it and knew that it was the zip the person was talking about. Unfortunately, whilst you unzipped her, she got life. Okay. So that is interesting. Complaints. I mean, the fact that a complaint comes against you doesn't really mean much. It's just an avenue or a basis for the organization or whatever body to officially start looking at the matter. Okay. So it's not really a big issue. The manual of the company will be important in dealing with matters like this. And so once it's a company, they should deal with it. But they talk about the former girlfriend at the office. And interestingly, from the story, she appears to have been the one who went to instigate the lady to now turn everything around, if the story he's telling us is anything to go by. And the fact that they had a public altercation before, I think inures to his benefit. Clement was talking about discrediting that witness, because obviously if it's a committee, the lady will state her case and will call her witness. And this is the witness. You also appear. I'm not sure you have a witness. No. And so in laying out your case, you will say that though the lady invited you to help her, this is how it stands. It's been so because you think you've been involved with this lady before, and because of the nature of your breakup, she's doing this, to spite you. Yeah. And once it's a public altercation, you can also call witnesses. Other witnesses, who saw the altercation and who knew you were an item together before, blah blah blah.
I saw the breakdown.
So it's an interesting one. Going to court, yes, like Clement said, let's exhaust the local remedies or the local processes. If you are not satisfied with that, you can move it to the next level. Same for the girl as well. She's saying that if the company doesn't do anything about it, but setting up a committee is doing something about it. Yeah. So I don't know what really she wants, but obviously she wants the guy punished. Let's see how it goes. I'm sure if the guy is not successful at the committee level, avenues are open up to him. And if the lady is also not successful at the committee level, she can also take it up. So that's it.
It's a tough one. I wouldn't want to find myself in this kind of situation.
Just don't go to the female bathroom. Just don't.
There are no more good Samaritans.
But so yeah, that's the question I wanted to ask. I mean, can you not be a good Samaritan anymore?
To be entering ladies.
No, you were passing by and you heard a scream.
Yeah, but now there's an issue. So just get the people. I'm sure there will be people around. So get somebody to help you.
All right. Okay. So we have to be careful. That's basically what it is. Well, it's time for us to take a look at our legal trivia.
Legal trivia. Did you know that you could go to prison for as long as 3 years if you intentionally distribute or intentionally cause another person to distribute the intimate image or prohibited visual recording of another identifiable person without the person's consent? This can be found in Section 67 of the Cybersecurity Act 2020, Act 1038. Take note and do the needful. That will be all for our legal trivia today.
Well, thank you for watching A Question of Law today. I want to say a big thank you to my guests today, Clement Kojo Akapam and Selam Adonu. Well, A Question of Law will come on your screens again next week. Don't go anywhere. Keep watching City TV. My name is David Kwekusechi.